until I recognize you by name before speaking, and for those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. For those on Zoom, at the bottom of the screen you can find a selection tab for the appropriate channel for the interpretation, either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. Reminder that all comments should be directed through me, the chair. For the
members in the room, if you wish to take the floor, please raise your hands. For members on Zoom, please use the raise hand function, and the clerk of the committee to my left and I will do our utmost to keep the speaking order, and we'd like to thank you very much for your patience and your understanding in that regard.
The committee has graciously agreed to allow a couple of questions from MP Idlout at the end, so we'll move on. We'll go all the way to 3:30, we'll go to 4:35, and then just toll the rest for the next meeting of officials that I'll introduce then. Welcome, Minister. Welcome, guests. Appearing today, we have with us the Minister of Justice, the Honourable Sean Fraser, Shaleen Curtis-McAuliffe, sous-ministre et sous-procureur général du Canada,
who's the Senior Assistant Deputy Minister, Owen Ripley, the Senior Assistant Deputy Minister, and the Senior Counsel, Joan Wells.
Witnesses in the second hour. A reminder that for the presentation today, Minister, you have 5 minutes to present, and without further ado, I turn the floor over to you. Welcome.
Thank you very much, Mr. Chair. Members, it's a pleasure to be here with you today to discuss the Combating Hate Act, Bill C-9. Just to set the table, one of the things that I think we need to reflect upon as Canadians is that it's a great promise of this country that we have the ability to live freely, regardless of the color of our skin, the God that we pray to, or the person that we love. Sadly, too many Canadians are robbed of these basic freedoms, not necessarily by operation of law, but too often by virtue of being subjected to hate in their communities. One
of the true promises of our country is the ability for Canadians in this nation to enjoy rights and freedoms. Unfortunately, there are a number of examples of persons subject to discrimination and hatred.
Canada that's worsened, particularly since the end of the COVID-19 pandemic. And it manifests itself in very painful and very human ways. When you have the opportunity to talk to people who face discrimination, and let's be specific, it's not just discrimination. These are firebombs on our synagogues. There are desecrations of our National Holocaust Memorial. We have seen far too many people feel unsafe to practice their faith. But this, though we've seen certainly a troubling rise in anti-Semitism, is not limited to any one particular faith. I have had the opportunity to speak with members of the Muslim community, the Christian community, the Hindu community, the Sikh community, who tell me the great pain they go through when they're unable to live their lives freely, be who they are, and practice their faith in public. It doesn't take long when you start to have conversations with communities who are subjected to hate to realize it's not restricted to the religious context. When I talk to members of the queer community, they tell me that of course it's painful if they've personally been subjected to hate, but when they read stories in the news, quand ils lisent les histoires dans le journal,
when they read stories in the news, there's a lot of fear.
That they fear to even hold their loved one's hand for fear they may be subjected to violence in their communities. It's important that we do more than offer our words and our thoughts and prayers to people who've been subjected to hate, often violent actions of hate. That brings us to Bill C-9. We, of course, in the recent federal election campaign, made a commitment to add new offences to the criminal code, specifically to protect the ability primarily for people to participate in the activities at their religious institutions, the buildings, the churches, mosques, synagogues, mandirs, It's important that we realize hate is not limited to the doorsteps of our religious institutions. Though this bill includes the criminalization of intimidation of those who would attend the buildings or structures designed for identifiable groups, both intimidation and obstruction of those facilities, we've decided to go beyond that initial commitment and introduce a standalone crime of hate. This is meant to recognize that hate is throughout our communities, in our parks, in our streets, on our university campuses, in our grocery stores. And the way that this particular charge will operate is to lay over existing criminal offenses to recognize that there is an enhanced moral culpability when you commit a crime against a person on the basis of who they are. And it also recognizes that it is not just the individual victim who suffers consequences when they face an act of hate, but the impact reverberates throughout the entirety of a particular community, causing people to have extraordinarily difficult and traumatic experiences on the basis of immutable characteristics with which they were born. In addition to the intimidation and obstruction offence and this new standalone crime of hate, we have established an additional criminal offence, the willful promotion of hate through the use of hate symbols. Of course, the willful promotion of hate is an existing crime today, but this recognizes that sometimes the tool you use to commit a crime worsens the impact on the victim, and in this instance, on the entirety of a given community. Beyond the specific measures that we included amongst these new offences, we also heard loud and clear from law enforcement and from communities who've been subjected to hate that charges are not often laid. We know that there have been just shy of 5,000 hate crimes reported in 2023, the last year I've seen complete data. We expect the number is much, much larger. We've heard very clearly that there is difficulties when it comes to understanding clarity in the definition and also with the administrative process. For that reason, we've added clarifying language to codify the definition of hate and remove the requirement for the consent of the Attorney General. Je n'ai pas beaucoup de temps pour continuer la...
I don't have much time to continue with my opening remarks, but I hope that you'll have an opportunity to engage on this very important bill to protect minority communities and to ensure that all Canadians have the ability to live and enjoy their freedoms across all communities of our country. Thank you, Mr. Chairperson.
Merci, Monsieur le Ministre.
Thank you, Minister. We'll have enough time for 2 rounds, I believe, complete rounds, perhaps even a third round. Now, here's the order. Mr. Brock first, who'll be sharing some of his time with Mr. Gill, 6 minutes, Deputy Member, House Father, and then Mr. Fortin, 6 minutes each. The floor is yours, sir.
Thank you, Chair. Minister Fraser, Justice officials, welcome to Justice Committee. Minister, since your government took office in 2015, crime in this country has been spiraling out of control. Violent crime up 55%, homicides up 30%, sex assaults up 76%, gun crime up 130%, and extortion shockingly up 330%. And yet, over the last 570 days, your government has only introduced 2 justice bills, C-63 and C-9, neither of which do anything to address the revolving door for violent repeat offenders. Why, Minister, after a year and a half, is your first legislative priority a bill that restricts free speech instead of protecting Canadians from violent repeat offenders?
Mr. Chair, with enormous respect to my colleague, I view the question to diminish the importance of the legislation that we're here to discuss today. Treating hate crimes as something less than urgent when members of affected communities are experiencing painful realities as a result of the hate that is lobbied upon them is not, in my view, the appropriate way to engage in this conversation. For the members' information, as we've discussed privately, we expect this fall, granted I've been in this position for a matter of a few months, most of which the House wasn't sitting, but this fall we have tabled the legislation we're here to discuss today. Within a matter of weeks, we will have one of the most comprehensive sets of reforms when it comes to the bail system and tougher sentences that our country has seen in many years, and a third bill before Christmas regarding intimate partner violence, sexual offences, and the role of victims in this process.
Thank you, Minister. I'm taking back my time.
Mr. Brock, just I understand that the minister should be succinct in his answers, but
Yeah.
just let him finish his thought.
Yes, I'm
cut him
taking
off
a
if
look
need
at the
be.
time it took me to pose the question, sir, and I've given him actually an extra 10
Yeah.
seconds
You're
to
spending it now.
respond.
Go ahead.
Do I have my time?
Go ahead.
Thank you. Minister, in 2015, there were 382,000 incidents of violent crime. In 2024, there were almost 592,000. That's a 55% increase. Any way you slice it, Minister, is an objective fact that crime is worse now than it was in 2015. Are you willing to accept reality, or are you going to choose to remain oblivious to what's happening in this country?
Look, I can recognize that crime and violent crime is a problem in Canada. That's why we are moving forward with an ambitious legislative agenda that's going to toughen the criminal justice system. But it's important that we realize that there are additional solutions. In addition to our changes to the bail and sentencing regime that you'll see in a matter of weeks, you're also going to see investments in the front line with 1,000 new RCMP officers, 1,000 new border officials, and more prosecutors. But we also have a view of the long-term need to prevent crime by making investments upstream that will tackle opportunities to pull at-risk youth out of the system, to invest in supportive housing, and to deal with mental health and addictions. But I think it's clear that we need to take action to toughen Canada's criminal laws to punish people who commit serious crimes.
Minister, Conservatives have introduced nearly 20 justice and public safety bills this Parliament alone on bail reform, sex assault, intimate partner violence, and organized crime, amongst others, while your government has tabled just 2. Are you going to support any private member bills introduced by the Conservative Party?
We don't have a blanket rule on supporting or rejecting bills based on the source of those proposed legal changes. We instead consider independently each of the measures that are brought forward by members, regardless of which party they may come from. I've had productive conversations, not only with you as my critic, Mr. Brock, with our colleague, Mr. Caputo, as well, and I'm willing to work in good faith. If there are certain challenges that cause us to believe that the proposed reforms will not make communities safe or would be blatantly unconstitutional,
Thank you, Minister.
I will have challenges.
Thank you, Minister. Will you commit today to repealing the principle of restraint under Section 493.1 of the Criminal Code to stop repeat violent offenders from being released back onto our streets? Yes or no?
You should expect to see changes to the way the principle of restraint is codified in the criminal code. I would point out that a repeal of the principle is not necessarily the appropriate language, given that the principle of restraint is recognized in common law and upheld by the Supreme Court of Canada.
So I'll take that
there
as a
are
no. Thank you,
challenges with
Minister.
it, and we will be making changes.
Thank you, Minister. Last month, in response to the Conservative announcement of the Stand on Guard policy, you tweeted out, quote, "This isn't the Wild West, it's Canada." Around the same time that you tweeted out this tone-deaf statement, in Hamilton alone, more than 80 shots rang out at bars after they were closing, leaving 3 injured. In Toronto, a 19-year-old was shot and killed in a mall bathroom. 2 17-year-olds were charged. In Ottawa, a Jewish woman in her 70s was stabbed and sent to hospital just for being Jewish. In Calling Lake, Alberta, a man wanted on a Canada-wide arrest warrant was charged in a violent home invasion where the homeowner was shot and killed. If these and thousands of other crime stories that are happening around this country on a weekly basis aren't indicative of the Wild West, what would meet your definition, sir?
This is an important conversation. Canadians should know that they have the right to defend themselves under the law in their homes if they are faced with such circumstances as you've described. And they have the ability to use force to do so when it is reasonably necessary. Jurisdictions that have adopted the proposal that you've suggested have not become more safe and have created new dangers. Just a few weeks ago in Texas, there was a 12-year-old boy killed by someone who thought he might have been an invader when he was playing Nicky Nicky Nine Door. You hear stories about people who are mistaken for invaders, who are delivering packages. What we're saying is where there is a set of circumstances that is unreasonable, the police should be able to make an independent decision. The law that was put in place by Stephen Harper, and it's a law that I actually support. You have the right to defend yourself in your home. I would remind colleagues that we have an opportunity to discuss the hate legislation that we brought forward. I hope subsequent questioners will take that issue as seriously as the government does.
Thank you, Minister. MP Housefather, the floor is yours.
Thank you.
No, it's fine. He used his time. Anthony, it's all yours. Yeah.
I believe Ms. Dillon wanted to go first, so I'll give her the time.
You're sure?
They don't even know who's
thank
going.
you, Mr. Minister, for coming here, and thank you I was a little bit surprised and a bit disappointed to hear Mr. Brock categorize this legislation as something that restricts free speech and minimizes its importance. This is legislation that comes forward after a shocking rise in anti-Semitism in Canada over the last 2 years that has led many in the Jewish community to feel very, very unsafe in the country. And last year, at my request, this committee, and Mr. Brock was there at the time, so M. Fortin était là aussi, we did a study that was called Heightened Anti-Semitism in Canada and How to Confront It, that came forward with many recommendations, some of which are included in the bill. For example, Minister, you're aware of the study on anti-Semitism the Justice Committee did last year?
Yes, I am.
So recommendation 10, that the federal government, that the federal parliament consider creating a new intimidation offense under the criminal code to more clearly and directly protect entrance to and exit from community buildings and worship and houses of worship and community centers, in addition to existing offenses that may apply in situations where such buildings are being blocked. Mr. Minister, is that in the bill?
It is, and I would note that recommendation had multi-partisan support, including from the Conservative Party.
And then recommendation 15, and in addition, you've also added an obstruction offense in addition to the intimidation offense that the committee had recommended. Recommendation 15, that the Government of Canada consider removing the requirement to obtain the consent of the Provincial Attorney General in order to prosecute certain hate crimes. Mr. Minister, is that in the bill?
Yes, again, that recommendation was supported by multiple parties, including the Liberal and Conservative parties.
Recommendation 16, that the Government of Canada take steps to ban the display of symbols of terrorist organizations that are listed under the Criminal Code. Mr. Minister, is that in the bill?
At risk of repeating myself, it's in the bill. And again, I reviewed the recommendation with sincerity and realized it had multi-partisan support at the time. I'm disappointed to see the tune has changed.
Recommendation 17, that the Government of Canada work with police forces across the country to develop a standardized definition of hate crimes and hate incident. The standardized definition of hate that was essentially referred to in that recommendation, essentially is in the bill as well. Is it not, coming from Supreme Court jurisprudence?
Absolutely.
So looking at the fact that for the last period of time there's been a lot of people, myself included, that have criticized the words that have come out and a failure to act, is this bill not exactly what was being requested in terms of actually acting in terms of what the federal government can do within our own jurisdiction to respond to the incredibly high rise of anti-Semitism and other forms of hate in the country?
Certainly. That was a major motivator to take action in the first place. And I should say, Mr. Housefather, thank you for your work on the committee and more broadly to advance measures that would combat hate in our communities. The process of developing this legislation relied heavily upon the work of parliamentarians from different parties to inform the final version of the bill. We did not seek to turn this into a partisan affair. My hope was this would cruise through the parliamentary process with support of all parties in the House. I still hope we can get to a place where that remains the case.
I certainly do too. Minister, I want to ask you something that's part of the bill but a bit auxiliary to it, which is the fact that in this country there's different jurisdictional issues which the committee ran into when we were doing this report, and que le Bloc québécois a soulevé à multiples.
The Bloc québécois raised on a number of occasions. It's a provincial area of jurisdiction.
Many of the issues that have preoccupied people, the demonstrations that have happened, including demonstrations on October the 7th in Toronto and Montreal, shutting down Concordia University, involved what many believe to be disrespectful actions versus necessarily illegal ones. You said something very, I thought, apropos at your press conference about setting a tone from the top about what this country expects versus what is illegal. But politicians have to set a tone, and what we don't think is Canadian is our values. Could you sort of repeat a little bit about what you said at that press conference?
Certainly. Canadians want to see leadership when it comes to treating one another equally. And Canadians want to see leadership when it comes to combating hate in our communities. We wanted to play a leadership role by introducing legislation that would criminalize behavior that crosses a high degree of moral culpability that threshold that brings something into the criminal context. But we should similarly recognize that there are many acts that we may find offensive that do not constitute hate for the purpose of the criminal code. We should nevertheless endeavor to condemn those acts, because the impact that a failure to speak out against hate it takes in our communities is still a negative impact that our fellow Canadians feel. We need to demonstrate leadership through our legislative action, but also in our words and in our deeds when it comes to condemning acts of hate or discrimination whenever they take place. And I think it's incumbent upon all of us, regardless of party, to speak out and to advance measures formally and informally that will have that impact, demonstrating that all Canadians belong in this country.
And I think one of the frustrations has been that existing laws have not been enforced by municipal police, by those authorities on the ground. And the point has been made that, well, the federal government should tell them to enforce the existing law. But, of course, the federal government has no power or jurisdiction to tell local police how to operate operationally on the ground in our cities, whether it's Toronto, Montreal, or elsewhere. But do you not believe that this law is sending a signal to provinces and municipalities and police as to what the federal government is expecting in terms of a tone from the top and in terms of enforcing the law?
It does two things. It both sets the tone, as you've indicated, but in addition, it also makes it technically easier for police to do their job when it comes to laying charges by providing clarity in the definition and removing the procedural step of requiring the consent of the Provincial Attorney General, both of which will add to the tone-setting exercise the bill may represent by actually making it technically easier to lay charges in the real world.
Thank you so much.
Merci, Monsieur Ambassadeur. Monsieur Fortin, la parole est...
Mr. Fortin, the floor is yours. As usual, 6 minutes to start off, please. Well, thank you very much, Mr. Chairperson. Yes, good afternoon, Minister. Thanks for being with us here today. Minister, there are some aspects of C9 I'd like to look at with you, but I'd like to start with one that really jumped out at me. It strikes me that the provisions under C9 to combat hate and anti-Semitism, etc., already exist in the criminal code. Now, I understand that we're not talking about exactly the same text, but there are already provisions, for example, that state that whomever foments genocide is committing a criminal act, who is inciting hate, who is fomenting hate, anti-Semitism, and so on and so forth. Who is causing harm or hatred, another offence at 340. So I'm not going to list all of the provisions exhaustively, but the fact remains that most of the situations that C9 is intending to legislate on, they already exist. Why did you deem it necessary to introduce legislation that substantially is a copy and paste of the criminal code? Response. Well, I understand your point, but I don't agree with it. There are new offences such as intimidation and obstruction. Let me use one example by way of response. You need to understand that the penalties change when we add these criminal offences for hatred. When what motivates the hatred is the colour of someone else's skin, well, we need to have tougher penalties. Moreover, we need to recognise the impact not only on individuals but on the entire community affected. Now, there's a new offence for willfully promoting hate.
We wanted to recognize that sometimes the tool you use to commit a crime makes it more serious. You can think of assault and assault with a weapon. It still would have been criminal before you used a weapon, but it recognizes the harm can be greater with the tool that you use.
But does that mean that the offences in the criminal code were not up to the task? They weren't up to snuff? For example, fomenting hate. There's already a penalty attached to that. It's all well and good to add 6 months or take away 1 month, but at the Bloc Québécois, we proposed legislation in the last Parliament that proposed to, in fact, eliminate those offences for religious reasons. And one might be able to complain to have a solid defence if one's actions were on the basis of a religious text. I can't see that in C9. Would that not have been useful? Possibly. Now, I am interested in hearing evidence on that, and if the majority of members of this committee are in favour of it, it won't be an issue for me. But when I look at the current exception, there is an obligation for good faith. And if someone's using religious reasons to foment hate or as a reason to kill others, that's not justifiable. But I would, of course, consider any recommendations issued by this committee, and perhaps you might wish to make an amendment, in which case the committee can amend the legislation. Thank you, Minister. Perhaps an amendment's all well and good, but I would have liked to have seen it in 6C9 because, you know, we have very little time in committee to deal with things that are self-explanatory or obvious. When in good faith one expresses an opinion on a religious issue or on a religious text that that individual believes is legitimate on the basis of their arguments, that strikes me that it has no place in the criminal code, that offence in 2025. But it would have been my fond hope that you share my opinion. Now, at a press conference, you said there are about 5,000 hate crimes annually. Of that total, how many have been prosecuted? Are you aware?
Yeah, I don't have the numbers of prosecutions in front of me. We'd be happy to provide that information on the back end or perhaps with officials in the second half.
À votre avis, Monsieur le Ministre?
In your opinion, Minister, were there as many prosecutions as hate crimes committed?
Expect not.
Expect not too. Et je me demande si...
And moreover, I wonder if the defence on religious exception has something to do with there weren't as many prosecutions as crimes committed, because the Crown prosecutor needs to determine whether they will prosecute, and in doing so they have to ask the question, will the accused have a reasonable defence to make? So I would suggest that you think long and hard about that offence based on religious exceptions, and that might be a wise thing to do. Now, I have very little time left. The definition of hate in the criminal code, is it too broad? Is it too narrow in relation to what you're proposing under 6C9?
The definition that we're proposing, I think, strikes the right balance. We wanted to respond to calls from law enforcement for the need for clarity, but this was not an attempt to change the definition that existed from the jurisprudence that came from the Supreme Court of Canada. It was designed instead to provide clarity to those who are actually enforcing the law on the ground based upon the existing body of case law.
Merci.
Yeah, wait.
Mon temps est fini?
Wait.
Your time's run out. Yes, my time's run out. Thank you.
Première ronde and the second. 5 speakers. Mr. Baber first for 5 minutes. Mr. Chang for 5. Mr. Fortin, 2 minutes et demie, comme d'habitude. Mr. Lawton, then 5 minutes, and then MP Dillon. Mr. Baber, the floor is yours.
I represent one of the largest Jewish communities in the country to which I also belong. Over the last decade of the Liberal government, hate crimes against the Jewish community have more than quadrupled. I believe that your appearance today is evidence of your government's failure to protect the Jewish community. To add betrayal to injury, the Prime Minister rewarded the worst terrorist attack in our lifetime with the recognition of a terrorist state. So please don't pretend that you're doing us any favors. But what I am seeing is that unless Bill C9 is amended, it will criminalize and prosecute speech that isn't criminal right now. So let's get into it. For 35 years, we used the Supreme Court definition of hatred from a case named Keekstra. It is an emotion of intense and extreme nature that is clearly associated with vilification and detestation. You say that you're trying to codify the Supreme Court jurisprudence, but your definition that you propose in Bill C9 is the emotion that involves detestation or vilification and that is stronger than disdain or dislike. You removed the words intense and extreme nature from the Supreme Court definition. Why are you trying to lower the bar to charge and convict people of hate speech? Is it to criminalize speech that liberals don't like?
Here, here.
No, and I'm just curious, in the preamble to your question, you indicated that there is additional hate speech that may not be criminal. And I'm curious, is there certain examples of hate speech that you think should not be criminal?
No, I'm saying that we have a clear definition of hate speech from the Supreme Court, definition that your government is trying to dilute through Bill C-9. Why are you diluting this definition by eliminating the words of an extreme and intense nature?
So when I review the definition of hatred, not just in the Keegstra but the Whatcott decision as well, it's clear to me that vilification and detestation are extreme manifestations. To the extent that you have a different interpretation, know that the intent of the legislation was in fact to codify not only those specific sentences in the decisions, but the different factors that the courts would have used over the years to identify. Should the committee feel that the legislation would benefit from a different reflection of the test that the Supreme Court has laid out, do know that that would not be a deal breaker for me, particularly if it would earn multi-partisan support and send a signal to Canadians that all parliamentarians want to combat hate in their communities. This was not an attempt to dilute the definition. It was an attempt to make good on the spirit of that definition and provide clarity to law enforcement.
It is doing exactly that. And in fact, the court in Whatcott has referred and reaffirmed the definition of Keegstra. I'm scared that you're going to use your proposed definition against Canadians and against members of the Jewish community. Your proposed definition is so broad, ill-considered by the courts, that it's probably unconstitutional. But should Canadians expect, like in the videos we're seeing out of the UK, that police are going to be knocking on their doors in the middle of the night for a Facebook comment?
Absolutely not, and I think the suggestion is patently far-fetched on the face of it.
All right. Bill C-9 will remove the requirement for the consent for the Attorney General to prosecute hate speech. The previous Attorney General said that the consent is a required safeguard. I heard your position during debate that in the future you may have a political Attorney General who will withhold consent to lay hate charges. But if the Attorney General can be political, then certainly a Crown Attorney can also be political, and a police force or a police officer can be political, and their judgment could be clouded politically, and they can potentially bring hate charges when it isn't appropriate and ruin someone's life. Have you considered that?
I've considered many aspects of this, and I like to start with the problem that we're trying to solve. We heard loud and clear from affected communities that charges were not being laid and justice was not being served. Stakeholders and, in fact, the Justice Committee had, including multi-partisan support, including your own party, have supported this particular change. I also hold the view, in addition to the argument that you've put in place, that with the extensive body of case law that has emerged over decades that has been informed the actions of law enforcement, the additional safeguard that the AG consent once provided is not as necessary today as it would have been back then. Wanted to solve the problem to ensure it was easier to lay charges where law enforcement can apply the law independently when they see hate in their communities in an effort to stamp it out everywhere.
It will be especially easier with you diluting the definition of hatred, but what's even more scary is that private prosecutions will also be exempt from Attorney General consent. Now, yes, the Crown may withdraw or stay charges, but the complainant could appeal either the Justice of the Peace or the Crown's decision to stay the charges and drag an innocent person into divisional court on judicial review. Do you really fail to see how allowing private prosecutions for hate offenses without the Attorney General's consent could be weaponized against innocent Canadians, including members of the Jewish community?
Mr. Baber, the time's up. Perhaps one of your members can pick that question up later. Thank you. Mr. Chang.
Thank you, Chair. Minister, Burnaby Central is one of the most diverse communities in Canada. So in 2022, someone shouted at me at Metrotown Saskatchewan Station. He said, and I quote, "What are you looking at, Asian? If you want to F-word, go to Davie Street." So as someone who has personally experienced discrimination based on my ethnic background and sexual orientation, I'm deeply concerned about the rise in hate crimes. However, I believe that it is equally important to ensure that Bill C-9 upholds and respects our charter rights. Minister, we have seen troubling rise in the hate-motivated incidents across Canada. Could you explain how Bill C-9 directly addressed the growing threat and why now is the right time for this piece of legislation?
Look, thank you. I too take very seriously the need to protect the rights of Canadians, but I take a broader view of what that includes. And in my view, it should include the right to actually live freely in your community, not just to have rights ascribed to you on paper. When we see hate take place in our communities and choose not to take action, we are complicit in hate's continuous fomentation. And I, for one, don't think that's acceptable. The changes that we're making to the criminal law are going to add real protections for communities of faith going to their places of worship, their community centers, their schools, for people more broadly to know that there will be additional charges, specific crimes of hate, if they are in fact targeted on the basis of their race or their sexual orientation, and to know that they will actually have changes made to the law so they are not a paper victory, but are likely to lead to more charges, and in turn that deterrent effect will have fewer instances of hate play out in their communities. This is about changing the real world experience of people who should not be subjected to hate in this country, and I think it's incumbent on all of us to actually have that frame when we're adopting laws or considering what amendments we may propose to them.
Minister, we know that schools and youth spaces have increasingly become target of hate-related incidents. How will Bill C-9 help ensure that students, educators, teachers are protected from intimidation and hate?
So the bill it's really important. Although this conversation has largely played out around themes of protection of religious minorities, it has a much broader application. Schools that are designed for a particularly an identifiable group in Canada would certainly benefit from the protection on the intimidation and obstruction offences. But we also wanted to make sure that we capture hate more broadly, so that if someone is targeted, regardless of whether it is a school for a particular religious community, a particular community of interest, that you would nevertheless have the protection of the law where a criminal act is committed against a person on the basis of some immutable characteristic belonging to an entire group of people. This additional protection, whether it's in our schools, whether it's in our grocery stores, whether it's on our university campuses, is going to heighten the degree of protection that Canadians actually enjoy in their communities, no matter where they find themselves.
Thank you. La parole est à vous, Monsieur Fortin, 2 minutes et demie.
2.5 minutes, Mr. Fortin. Well, thank you, Mr. Chairperson. Minister, the Criminal Code states currently that the Attorney General needs to provide consent before prosecuting hate crimes. C9 will delete that prior consent. Could you please tell me what that previous prior consent, the purpose of was, and why delete it now?
At the time that the hate provisions were put in place, there were arguments made that formed their way into law that offered an additional degree of protection. The argument would have been to ensure that crimes had that second layer of approval before, in fact, charges were laid. In my view, given the fact the world has changed, the law has become clearer over many decades since the Keegster decision in particular, and law enforcement have gained experience, you no longer have that same need. We also, as a result of the rising prevalence of hate crimes in our communities, heard from communities more frequently that this is a problem that's getting in the way of charges actually being laid. I would make one final point, not to eat up your time, and if I need to extend by 30 seconds, I will. It's important to understand that provinces maintain the ability to implement pre-charge screening at their discretion should they wish. British Columbia, for example, does that for efficiency purposes. Other provinces could have the ability to do the same.
Merci, Monsieur le Ministre.
Thank you, Minister. I'm not the only one to think this, but with this prior consent, I saw it as a guarantee that the prosecutions would be serious when it comes to hate propaganda. If it's deleted, this provision, won't it allow an individual to prosecute or sue frivolously when the Attorney General would not have given consent had he been obligated to do so?
So, and I think this touches on a question that one of the previous questioners put forward. I think it's important to keep in mind as well a difference between public Crown prosecutions and private prosecutions, there's a judicial screening process that will be in place to prevent the kind of frivolous or vexatious litigation that may exist. But when it comes to the Crown's application of the law, the law enforcement's application of the law in communities, I believe that they have the ability, based on the extensive body of case law, based on decades of experience, and based on training supports that are made available, to effectively police the laws as they're written on paper, so the outcomes we're seeking in communities can be fully realized by Canadians.
Time's up, Mr. Fortin. Well, I understand there's no good reason to delete that consent it was used for. Well, I have a different point of view, but I understand yours.
Minister, thank you for being with us today. C9 makes reference specifically with hate symbols to public spaces. Just to confirm, does that include the internet?
Generally speaking, the law will apply equally online as it does in real communities.
So this bill will affect what people can say and write on the internet?
Just in the limited circumstances where there is the willful promotion of hatred against
It will apply
someone.
to the internet. The internet is within the jurisdiction of...
It would be possible that someone could commit a hate crime on the internet, certainly.
So, building off of Mr. Baber's points about the lower threshold for the definition of speech, there is, under this law, assuming Bill C9 passes, something that might not be legal to say today on the internet. Or it might be legal to say on the internet, could actually be illegal in the future under C9, could it not?
No, that's entirely inaccurate, and I say that with no judgment to your perspective, but let me explain. The only circumstance where you could imagine some online comment attracting scrutiny under this law would attach to behavior that is criminal today but would be punished less severely. The symbols piece that you pointed to, for example, is attached only to the willful promotion of hate. This is not a blanket symbols ban. The willful promotion of hate is a crime today, but we want to recognize a distinct charge where that same behavior uses certain symbols of hate to bring a higher degree of culpability. So there is no new human behavior that would attract the scrutiny.
I understand, but I'm building off of the discussion earlier on the definition. Is your view that the change in wording, and there was a change in wording, you made a deliberate decision to change the definition that was spelled out in Keekstra and reaffirmed in Watcott. Is your view that your definition in C9 will not capture anything beyond what is currently captured right now by the hate definition?
The definition was an attempt to codify, and the reason that there was a... This is a yes or no question, Minister.
Is there at all a lower threshold or a broader net on hate in Canada after C9 if it passes?
My view on the definition question, because the offences I would give a different answer to you for, but on the definition, my view is that it codifies the same behaviour that is there today, and it was meant to provide clearer guidance to law enforcement in the criminal code to apply the existing standard that has been recognised by the Supreme Court.
Because the same arguments that are being used by you and your government to push Bill C9 to protect people against hate, which on the surface sounds incredibly noble, but these arguments are the same arguments that have led to the United Kingdom having police literally knocking on people's doors over their tweets. So what guarantee can you give Canadians that we are not headed down that very road, especially in the context of other priority areas identified by you and your government, such as the Online Harms Act, which was introduced twice, actually, in the last two parliaments?
So this legislation is not identical in kind to the reforms that have been put in place in the UK, and we've actually looked at their experience and see that there are real challenges with how it's played out. For example, we've got a different approach where some jurisdictions around the world have adopted a more blanket glorification that could attract the scrutiny of a liking a Facebook post, for example, and we chose a different path. We instead tried to be very clear that we would not interfere with the charter rights of Canadians to freely express themselves, but at the same time make it easier to lay charges where hate crimes are committed today. To the extent that you think there is a better way to clarify and codify the existing definition, do know that I believe in Parliament, and I don't care which party comes forward with these amendments. If it creates multi-partisan buy-in to codify the test, that's okay by me.
Can you guarantee that if C9 passes, no Canadian will end up being charged because of something they've posted on Twitter or Facebook?
Well, if they commit the crime of willfully promoting hatred against another person.
A crime with a definition that you're changing.
So, but it's possible that they could be convicted for what they willfully promoting hate online today. So certainly I would hope if someone commits a crime in the real world or online that they would face the appropriate criminal penalty if in fact it's captured by the code.
We had in my riding a very disturbing case a few weeks ago where someone had mowed a swastika, a Hakenkreuz I should say, into their lawn and was charged under the existing criminal code definition. They displayed a symbol. It was found to be willfully promoting hate. Law enforcement and the Crown agreed that they could lay that charge. So why is your bill at all necessary when we already have existing powers, which, to Mr. Housefather's point earlier, are simply not being enforced as often as they could be?
Look, this is an important question. I'll answer it very quickly. When you have the willful promotion of hate, the person who's convicted of that could still be convicted, but also of a second charge, the willful promotion of hate using hate symbols, which would attract a greater degree of culpability and potentially a greater penalty, recognizing that the use of hate symbols, when you're willfully promoting hate, can cause greater damage to both the individual and the entirety of the community. So I don't find these points to be inconsistent with one another, but instead that behavior could potentially face an additional charge with a more serious penalty because of the manner in which a person chose to promote hate to cause more damage to an affected community.
Thank you. Ms. Dillon.
Thank you, Minister, for being here today. In recent times, we've seen attacks on religious institutions, places that are sacred to people of faith who worship. Somewhere where they're supposed to feel safe and secure, they often do not. My question to you, and you've spoken about them being able to safely access these places of worship, and community centers as well. How will the new intimidation and obstruction offenses make that a reality?
Part of ensuring Canadians are able to be who they are and to live freely as a citizen of this country is ensuring that they can make choices about how they live their lives day to day, including how they practice their faith or participate in their community. A big part of that is how we gather, celebrate special occasions, and share cultures and traditions with one another. We have seen real-world challenges where groups who may have started out as being innocent protesters have escalated their behavior over the time, where they in fact may physically block people from attending the institutions that allow them to be part of their community, or conduct themselves in a way that is specifically designed to threaten another person from taking part in the activities that take place within those spaces. The spaces in which we gather in a country as diverse and multicultural as Canada are a big part of our cultural identity as a nation. We believe that the spaces that allow communities to fully celebrate their cultures and tradition deserve a degree of protection, and have found, in my view, an elegant solution that allows us to use the federal tools at our disposal to offer protections that allows Canadians to choose for themselves how they spend their days.
And if you can please provide some clarification, there has been misinformation on this bill saying that it bans protests near religious or cultural sites. Can you tell us what this bill can do to protect the right to peaceful protest? Because there has to be a balance.
Certainly, and I find some of the previous questions ironic in this regard. In fact, the argument is somewhat self-defeating. On the one hand, there's a suggestion that free speech is somehow impacted, and in the next breath, you hear the question suggest that in fact it doesn't represent a change in the law. And those two positions cannot possibly be reconciled. When we developed these pieces of legislation, it was a priority to ensure that we didn't have a negative impact on the ability of Canadians to fully enjoy the rights that are protected by the Constitution, including the right to free expression. That's why, for example, when we wanted to deal with symbols of hate, we didn't use a blanket symbols ban, but instead attracted to the criminal behavior of willfully promoting hatred against another Canadian. There's a difference, in my view, from protesting a cause against some initiative, something that's happening in the world that you fundamentally disagree with, and showing up to intimidate a person from practicing their faith, or physically obstructing them from attending their community centers, schools, or places of worship, and understanding where that line exists as between sharing an opinion, broadcasting information, and causing harm, sometimes violent harm, to your fellow Canadians is an important distinction. And I think that this bill does a good job of scoping in behavior that I believe should be criminal, that will offer a greater degree of protections to Canadians to be themselves without infringing the protections to the ability to express yourself freely.
And because we need a good balance between freedom of expression and hatred. So this is one other question I have for you. You chose to have a clear definition of the word hatred. Why was this necessary to include this in the criminal code?
So law enforcement shared with me that a clear definition in the criminal code would help them actually lay charges when they see it. Eliminating ambiguity in the code can change how the laws are applied on the ground, even where they don't necessarily change the substance of the law that underlies the proposed amendments to the code that we're talking about now. In addition, I think it's essential that we recognize that this cultural impact within law enforcement has a real-world effect on the ability of Canadians to seek justice when they are in fact subjected to hate, not just on behalf of themselves, but on behalf of an entire community. So by codifying the principles that were recognized in the Keekster and Whatcott decision, we have an opportunity to send a clear signal to law enforcement that you can in fact enforce these crimes when you see them, and it gives victims of hate crimes a sense that justice will prevail at the end of the day.
Thank you, Ms. Dillon. Thank you, Mr. Fraser. We have time for Mr. Bever and Mr. Gill that will be splitting some time, Ms. Latanzio, and then we'll go to MP Edlow. So floor is yours.
Thank you, Chair. Minister, you have said that Canada is not the Wild West. Yet, meanwhile, violent crime is up 55%, sexual assault 76%, extortion has surged. Extortion has surged by 330%. How bad does it have to get before you admit that Canada currently appears lawless?
Well, when I look at some of the proposals that we've seen put forward by your party on the House of Commons, it becomes clear that copying and pasting the American approach to criminal laws or to guns would not enhance public safety. The Conservative policy of wanting to legalize assault-style weapons, I think, would make Canada a more dangerous place. The repeated introduction of reforms that certainly violate the Constitution would not make Canada a safer place. And the example given earlier has led to a whole series of behaviors, including recently in the state of Texas, the accidental death by gun violence of a child who was ringing doorbells. It's obvious when you look at some of the proposals that have come forward that we need to have evidence-based policies, and that's what you're going to see with the bill that we put forward in a number of weeks to help change Canada's criminal laws to make our country a safer place.
Minister, many of the offences in C9 restate conduct already captured by existing criminal code, provisions such as Section 423.1, intimidation, 319, public incitement of hatred, and 264, harassment. Would you agree that the core problem today is uneven enforcement of current laws, not a lack of legislation? What evidence did the department rely on to conclude that additional offences rather than improved enforcement were needed?
I think both are needed. I take your point that enforcement can be improved, and sometimes that will be with more officers on the ground, sometimes it will be with enhanced training, but I do think that we could have better and more equal enforcement of laws that do exist on the books. But I also think, based on the feedback that we've had, not just from law enforcement, but from affected communities, that these changes are necessary because you can recognize the significant difference when a person may assault someone because they have a disagreement that goes sideways versus specifically targeting someone on the basis of their religion or the color of their skin, which doesn't just impact the individual victim, but the entirety of a community. We believe that warrants, though it may be the same behavior in the instant, the effect is not the same. And we think that greater harm that befalls on a community demands a new charge with increased penalties to recognize the severity of the impact of hate crimes on affected
Minister,
communities.
I cede my time to Mr. Weber now.
Thank you. Minister, do you really fail to see how allowing private prosecutions for hate offences without the consent of the Attorney General could not be weaponized against innocent Canadians by vexatious litigants or political opponents?
I have a lot of faith in the ability of courts to police frivolous and vexatious litigation. You see the opportunity for courts to screen out those kinds of complaints with great frequency. If the committee wishes to take evidence from experts in the space to understand the protections that do exist and where it can be improved, do know that I don't come into this with some preordained outcome. I believe in the work of Parliament. I believe in the ability to take evidence from witnesses and to propose amendments, and would consider each of them in good faith should you wish to move forward with some.
I also have a lot of faith in the courts. The problem is that by the time you get through due process, you may be taken through litigation, your reputation may be ruined, you may incur a lot of legal fees. So this is a major concern for myself. With respect to the new hate offense, the new criminal hate offense can be laid on top of any offense under any federal law. Is that correct? Yes or no?
Yes.
And so an offense under the Elections Act or an offense under the Canada Labour Code may attract criminal prosecution. Someone, for instance, could be charged criminally for non-payment of wages under the Canada Labour Code. Isn't that correct?
I have a hard time understanding how non-payment of wage, if there's a motivation of hatred towards another individual and you commit a crime against that individual because of who they are, it could attach to virtually any charge. The likelihood it would come up in that set of circumstances, I think, would be quite small.
You're basically talking about tacking on criminal charges on what is otherwise civil, non-criminal behavior. This is very concerning. You may have unintended consequences when you combine that with dilution of the definition of hatred, as you're doing, and the possibility for private prosecutions without Attorney General consent. This is a very concerning piece of legislation, Minister. Thank you.
Time's up. Perhaps Mr. Housefather can let him continue, or over. Either way, it's over to you, Anthony, for 5 minutes.
Thank you so much.
Okay, we don't need to see Liberals ask another Liberal a question. We're going to switch over to Ogo, the mighty Ogo. Let me close that one in the background. Boom. I probably need to turn this up. Let's see. Let's see.
Example, the parliamentary budget officer gets his budget from Parliament. Elections, same thing.
There we go. Okay.
And also the Conflict of Interest and Ethics Commissioner. So that's the kind of model that the rest.
This is the Public Service Integrity Commissioner, and they're talking about conflict of interest as this committee has been reviewing the Conflict of Interest Act. Oh my God, it's Khaled. We tuned in at a bad time. Sorry.
You know, I personally think that it never hurts to look at anything that you want to look at, but I do think that our mandates are all very different, requiring different expertise, requiring different firewalls in terms of confidentiality, some of which are not compatible. So, for example, in my case, it is the Auditor General. If there is a complaint under the PSDPA against me, it is the Auditor General who would investigate or who would consider those allegations. I think that, and they, we have cases with one another, right? And so my personal view is I don't necessarily see a room, if you're just asking me offhand, but I haven't done an analysis, I don't see enough of a commonality in our mandates to be able to do that offhand.
Fair. Are there cases where multiple commissioners would have to get involved?
Not in our case. I can't speak for the other commissioners, but we are very at arm's length with everybody. I don't go to deputy ministers' meetings. We're at arm's length from everybody.
Do you think that your office functions as efficiently as you would like it to?
I have never worked anywhere where I didn't think I could gain more efficiencies. So that's for as long as I work and as long as I have a job, I will always be looking for more efficiencies.
On that, then, what are your top most issues that need to be more efficient in your office?
I think we're working on a lot of them. I think I can tell you some of the things that we've done, for example, is, with some of the funding that we did get, our IT infrastructure had been older than 2007. It predated the office. It was on the verge of collapse. And in addition to that, it didn't really allow us to have any kind of meaningful data analytics. So now that's transformed, and we're in the process of starting to collect data because, of course, we can't collect data when data didn't exist. And that is a work in progress and something that we are committed to working toward some more. We are also looking at just the processes and the way we do things, and we have discussions, a minimum of weekly, to see if we can do things better. Quality control is critical. I am issuing quasi-judicial decisions. I know I have been asked in the past about the use of AI. It's not an option for my decisions or legal analysis. But we are very open to and are constantly seeking better ways of doing things.
What is the biggest challenge that you're facing right now in your office?
Just a brief answer, please.
Staff and space.
Thank you. Thanks very much.
Thanks, Ms. Cleed. Now we'll go to Ms. Gaudreau, please.
Moi, j'ai seulement 2 minutes 30.
I only have 2.5 minutes, but I'd like to know if there's any pertinent information that you would like to add to what we already have. Anything constructive which would help you to make your life easier. Well, last week, I was at the Parliamentary Library with other commissioners to reply to questions that their staff might have and new parliamentarians might have. So I'm quite sure that the librarian would be quite prepared to prepare and offer a briefing session or an orientation section on what we do on our office. All staff and employees of the commission constitute a very, very loyal and performant team. And I want everybody to know that we really, really need more resources if we're to completely accomplish our mandate.
I stand ready, and just in response to Madame Rochefort's last question, I would never ask for money willy-nilly, and it would be fully supported by data and a full explanation. It's not about a number, it's about what we need, and that's where we get to a number. So I really do hope that I have that support, and I really do believe that it's an important mandate for the Canadian public. With every decision I write, and as I said, some are very, very lengthy, I try to explain, especially in cases where there's no finding of wrongdoing, pourquoi il n'y a pas une détermination qu'il y avait quelque chose.
Particularly when we don't have a determination of
looked at, and that we were really serious about it. And I hope that they can come away feeling that there is a check and balance.
Thank you. We'll go to Mr. Patzer, please.
Thank you very much.
Where's Barrett?
How many employees do you have working for you again?
I think at this point we're just over 40. Yes. Is that right? I mean, depending on, some people come and go, but we're about, I'm going to say low 40s, like 40, 41 right now.
Okay. I do have a bit of a tough question for you. couple of years ago, the Center for Free Expression said, and I quote, "After approaching PSIC without success, dozens of public servants in desperation have contacted volunteer whistleblowing advocacy groups like the Center for Free Expression, and we get to hear their stories. Almost without exception, they describe treatment from PSIC that's dismissive, obstructive, often humiliating, and always fruitless in the end. PSIC appears to be institutionally hostile towards the people it's supposed to protect, seeming to view them as liars and troublemakers while they apparently treat the alleged wrongdoers with deference and consideration." End quote. I guess the buck, you're at the top of the charts. The buck stops with you. I'm just curious, when you hear a statement like that, what do you have to say about a statement like that?
Well, I've met with the Center for Free Expression on a number of occasions. I've been in this job for 2 years, and as I've just said, I have never worked with a group of people who are more dedicated to the mandate than the group that I'm working with now. So I cannot speak. I don't know when that statement was made. I do believe it was prior to my arrival. So I cannot speak for that or where that came from. But I can tell you that in my estimation, we have an excellent team who is dedicated and who is, each one of them are trying to treat everybody with respect, and they really do respect people. They respect the whistleblowers, they respect the respondents, and they respect the witnesses. And that's what I've seen since I've been in the office. So I can't speak to why they said what they said at the time that they said it, but all I can do is tell you what I've seen in the office since I've been there. That doesn't mean we've been perfect. I'm sure we have not been perfect, but we really try to be perfect and to try to right wrongs if there are any wrongs. That's, I guess, what I have to say about that.
Okay, so have you ever had to remove an employee because of misconduct towards a whistleblower?
At all. Not at all. And, we have a process now where we we have an intake process whereby I sit at the table with the analyst, with a lawyer, and we discuss the cases that we get or the submissions that we get, and I see a lot of compassion around the table always. And so I've never even come close to having to intervene.
Okay, thank you for that. Like I said, I know it's a tough question, and I appreciate that you have confidence in the workforce there. I guess I only got a little bit of time here left. I guess just kind of going back to the sheer volume of cases that you are seeing. Are you formulating a plan? I know we've talked a lot about funding, but do you have a plan in place, or are you working on a plan to try to really shorten these timelines to try to address the concerns that are part of the concerns that I think have to do with timelines previously? I think that's part of why we hear what we hear in older in that article from 2022. But do you have a plan to try to shorten the timelines to get people a resolution faster and quicker, so that way they don't have to endure repeated harassment from a superior or a colleague?
There's only so much juice you can squeeze from a lemon. At the same time, every single day we're looking for more efficiencies. Every single day we're looking to see how we can provide a fulsome response in each case as quickly as possible. We are looking at our organization now. I'm considering so many different options about maybe different classifications or different expertise. Not a day goes by when we're not thinking about that. But there really is only so much juice you can squeeze from an orange.
Thank you very much. I think we're done. Do you mind if I just ask a couple quick questions? I've been on this committee, the whistleblower file, for a while. I think I brought up, I may have missed the answer, and I do apologize if I did. The advisory task force on whistleblowing, what has been your involvement with that, or your office's involvement?
Shortly after I arrived, they asked to speak to me, and so I did, with Brian, in fact. But that's it. Otherwise, we're not involved. I think it's a bit late. They've written their report.
Have you seen the report? Or?
No.
No?
No idea.
Is it published to you?
No. I mean, I'm again, it's Grapevine. Grapevine says that they've completed their report, but
It was due, over a year ago.
but
I'm
I
just
have
curious.
no idea where it is or what's in it.
Okay. Maybe it's something we can follow up internally with among ourselves. But thank you very much for your time. It's nice to see both of you here again. I'm going to excuse you both and go on to some quick committee business regarding the budgets in the schedule. So thanks very much. Leave the water behind.
It's always a pleasure. And if there is a need for more information, don't hesitate to reach out.
Perfect.
Thank you.
Just I'll get to Mr. Patzer. Let me just. Okay. Thanks again. The clerk has distributed 3 budgets we need quick approval for. As always, these are maximums, and we probably will not spend anywhere close. So the first one is, if I could read, it's $500 for the PBO study that 2 reports that we've already done. If we can get approval for that. Thank you. One was for water only. Second one for today's Public Service Integrity Commissioner, $500 for the water. I'm sure we'll come in quite a bit below that.
Si je suis d'accord, Monsieur le Président.
I agree, Mr. Chair. For consensus, you have to take a look at me, and if I do a thumbs up. Was there a delay in the interpretation? Were you listening in?
It's the meeting we had, or our 2 report stage for the Consul General for New York, which was $1,000, and again.
That better not be in camera when you
close
guys
to
do that.
So we're all fine with that? Wonderful. Just very quickly. Budgets, just updating everyone back and forth between ministers. Minister Lightbound is made itself available for October 23rd for the first hour for Canada Post, which we had requested. Leaves the second hour, and this is going to get you. I originally suggested we move back some of the study because we didn't have the minister nor Canada Post would be available. Now that he is, I figure we'll do the second hour, will be witnesses. I had said we'll move the request for witnesses back because I thought we'd do the study later. Now it looks like we'll start it. So I will ask everyone to get witnesses in by next Tuesday for 3 o'clock. Okay. So some have already been submitted. Just resubmit your list, please, with your priorities. The 28th, then we'll also fill in from that witness list. President of the Treasury Board has made himself available for the 30th. At the same time, of course, that Minister Lightbound, PSBC, is going to be available. So we are going to take the first one who said yes, which was Treasury Board. So they'll be here on the 30th for about an hour 20. That gives us just enough time to get through appropriate rounds. We've asked Minister Lightbound now to find another time for us, and he's agreed to reappear on his mandate. The original request was for the mandate, but he's doing Canada Post first. So he will get back to us hopefully in the first week of November for 1 hour on his mandate briefing and everything else with us. And that is what I had. Mr. Patzer? Sure, and then Ms. Block. Sure.
Thank you very much, Mr. Chair. Since we're in committee business, I would like to move a motion, if I may, and I will get my staff to circulate that to the clerk here, if you don't mind, Andrew. So I'm just going to read the motion in. You'll get a copy of it, so you'll get to see it, but I'll read it here quickly anyway. And so whereas the government recently announced a defense investment agency housed within Public Services and Procurement Canada, which is overseen by the Standing Committee on Government Operations and Estimates, that pursuant to Standing Order 1082, the committee studied the creation and planning of the Defense Investment Agency for no fewer than 2 meetings, that at least 1 meeting be scheduled no later than October 28th, that the committee invite officials from Public Services and Procurement Canada, the Secretary of State for Defense Procurement, and the CEO of the Defense Investment Agency to appear for 2 hours, that the committee also invite officials from the Privy Council Office, the Prime Minister's Office, the Treasury Board Secretariat, and any department involved with appointments made for the Defense Investment Agency. So that's the motion I would like to move. I think given that there's this new Defense Investment Agency, there's been a gentleman appointed to it. He is, we have called for him as the CEO. I think it would be good to have him come talk about his vision for defense procurement. We know the government has done this, created this agency as a chance and an opportunity to streamline procurement. I've read several news articles actually on, I guess, kind of what the next steps and what the next phase is for the government when it comes to procurement versus purchasing versus also our defense strategy here in Canada as well. But I do think for the sake of this new agency, it would be helpful to have the Secretary of State and the CEO up here. I've got a few other names listed here as well too, but I think this is a very friendly motion in line with other typical motions that this committee does by inviting either ministers or government officials to talk about what their mandate is. Has it been circulated, Chair? Okay, right on. So I guess I would maybe turn it over to the committee if they to read it. If there's any questions, happy to answer any questions on it. But I do think this is a pretty simple, straightforward motion.
Okay, I'll start a speaking order. I have Ms. Rochefort.
Simply, I'd like to understand what is the difference in this motion with the one that our colleague, Madame Gaudreau, made with respect to Canada Post, where she had to give notice. So how is this? My impressions were that when Madame Gaudreau brought forward the motion for Canada Post, she had to give us notice. And then, so tonight there's no notice. I'm comfortable just with motions being brought forward. Like this without me having had a chance to read it.
Yeah, we went into committee business to discuss and get the budgets approved.
Okay.
When we're in a committee business, people can bring in table motions.
So why was she not allowed to bring a motion that when she had one a few weeks ago?
I'm not sure we're referring to, but the issue at hand. We're discussing the motion at hand right now.
So I'm just trying to understand, I guess,
we're
how
in
motions.
Committee business.
Yes.
He's tabled a motion, so
Correct.
we're debating the motion.
Okay.
So I have speaking orders. So Ms. Khalid.
She doesn't know how motions get tabled in committee.
I am not able to view the text of the motion, and I would respectfully ask for you to suspend the meeting until we can. I'll just wait.
Can you repeat that?
Thank you, Chair. I was just wondering if you can perhaps suspend the meeting while you distribute to us paper copies of the motion, because I am not able to access it on my phone at
Perhaps
this
you
time.
can share it with one of your members.
I would prefer to have my own copy, Chair.
Oh, okay.
I would like to also suspend the meeting so I can discuss this with my colleagues. This is a bit of a surprise.
Sure,
would
we
have
can
loved
suspend,
advance notice.
Say 5 minutes?
I would prefer 10, Chair.
I'll give you 5.
We'll see. Thank you, Chair.
It's not a we'll see. You don't determine this, Ms. Khalid, and I appreciate your humor with it, but we'll give you 5, okay?
Get set straight. To be honest, I think we're going to call it here. It looks like this committee's kind of, in committee business, and they're just tabling boring motions. There's nothing really to see here. And I've taken a look at the other committees. Pretty much nothing's really going on. We could tune back into the Justice Committee, but the juicy part was the first hour with Fraser being in there. So, we are not live tomorrow, and the House is off next week because it's Thanksgiving. So, basically, we won't be live until the week of the 20th, which is week and a half away now at this point. There will be clips coming out on the channel over the weekend, and for next week, there's a couple good interviews with recently that of Danielle Smith, and there's been Pierre on podcasts and stuff. So I'll get some of those juicy clips out, so you guys don't have to watch the whole hour of the podcast. But we aren't till the 20th. Yeah, the 20th is when the house resumes. So I don't go live on Fridays. The house is only open for usually a few hours anyway. Why aren't they in next week? Because it's Thanksgiving, and in the government they get the whole bloody week off. So your tax dollars are hard at work there. But I do want to just quickly shout out the Cindy Wilson for the super chat, Squishy Bugs for joining coffee support, Ort Cloud for the super chat as well, and just me, Nicole. Thank you guys for the super chats. Really appreciate you guys. But yeah, that's it for us here, and a week off just for Thanksgiving. I know, it's ridiculous. It's absolutely insane. If there's any committees that do get called last minute, obviously I'll be covering those, but it looks to me like we won't be live again until the week of the 20th. So happy Thanksgiving to everybody. I hope you guys all have a good weekend. And thanks for watching and tuning in, guys. Cheers, everyone. See you soon.